All right, so is it proper for a lawyer to engage in business with a client? Well, the short answer is, yeah, you can do that. There are some real restrictions on it, and you have to be very careful, but you can do it. It's not something I did very much in my 40 years of practice, but that doesn't mean it's improper, doesn't mean it's not something you can do. It's a personal thing, but if you're going to do it, you need to know what the rules are. And the Professional Rules of Conduct 1.8 kind of go through what you have to do. So let's say you're a new lawyer and this business opportunity comes up, but it's with a client that you represented or are representing. What do you have to be concerned about? Number one, the terms of your agreement with your client have to be fair and reasonable. What the professional rules are trying to get at is, because you have a certain advantage, because you're the lawyer, you have to go out of your way to make sure that what this agreement is that you have with your client / business partner is fair and reasonable to him or her, not to you, to him or her. So the terms of the agreement, what you're going to do, what the business is going to do, what your role is, what your client's role is, what are the liabilities and exposures, have to be disclosed to the client in writing. And boy, one of the things I would really press on you if you're going to do this is make sure you're disclosing everything. Sit down and what if that agreement. Because at some point, if something goes wrong and there's a grievance filed against you or something, and they take a look at this disclosure statement, and there's something that you left out, maybe you even left it out not on purpose, you just didn't think of it, and the disciplinary body thinks it was a material omission, you could have a problem. So it should be a very exhaustive disclosure to the client. And what the rules say, and this is very interesting, it says, in a manner, you must disclose this in a manner that can be reasonably understood by the client. So what I would do, what I have done, is eliminate all kinds of legal nomenclature. Try to write it as if a layman is reading it, because a layman's reading it. Avoid legal terminology, because the client at some point could back and say, well, there was legal terminology in here in this disclosure, but I didn't know what it meant. So it's not really an effective disclosure. Now, the rules also tell you that you have to advise the client to get a third-party attorney opinion of the relationship. It doesn't say you have to do it, that the client has to do it. It says you have to advise them of it. I go one step further to be very safe and tell the client, I'm not going to enter into this agreement with you until you actually do get an opinion from another attorney. And that opinion is going to be in writing, and I'm going to have a copy of that. I think that protects you as well. And the attorney that does the third-party opinion can't be somebody that you refer to the client to. It should be something that the client goes out, he or she retains that attorney on their own, and if the attorney looks at the agreement and says, this seems fair and reasonable, everything's been disclosed, you get a copy of that letter and you stick it in your file. Now, you need written informed consent by the client. And we've talked about this before. Informed consent means exactly that. That isn't just that they're signing the consent form, but they're disclosing that they understand everything in the agreement. All of my questions have been answered. I have fully explored all the ramifications with my attorney. That's an informed consent. Now, what the rules are trying to do, as I said, is provide an unfair advantage, because, and this is always tricky for me, you're mixing your interest with the interest of the client, which normally in law we never do. The interest of the client is always primary. Our interests are always secondary. But in a business relationship, they may be, you're a partner with your client in some kind of endeavor. Well, that's problematic right off the bat, because you're mixing those interests. Now, if you weren't the person's lawyer, it wouldn't be a big deal. You have interest, your partner has interest, but you're an attorney, and this person is your client. That's where it becomes a problem. And one of the things that they might look at if you ever end up in front of a disciplinary committee, is did your legal advice that you gave your client, was it in any way colored by the fact that you had a proprietary or pecuniary interest in this matter? You really need to ask yourself that question as you're even exploring whether you want to do this. So these are some of the things that you must consider if you're considering entering into some kind of a business transaction with a client.